Pode começar, Paula.
Olá a todos e todas, bom dia. Estamos agora no nosso 5º painel da Conferência Internacional sobre Acesso à Justiça e Clínicas Jurídicas. Nós teremos o painel agora de como construir uma clínica jurídica com o professor Jeff Baker, da Pepperdine, e com a professora Chato, Olivas-Quinto, da Universidade de La Salle, Manila, com a mediação da professora Taysa, da Universidade Federal do Paraná. É um prazer recebê-las aqui no YouTube. So, good morning, everyone. We're going to start our second panel of today. Is how to build a new clinic with Professor Jeff Baker from Pepperdine, Professor Rosario de Manila, and with the moderation of Professor Taysa. She's going to be our moderator today. She's from the Federal University of Paraná. So I wish you a very excellent event, and I see you soon. Então, declaro aberta a mesa número 5, em nome do IBMEC São Paulo. Bom evento.
Oi, pessoal. Bom dia a todas e todos que nos assistem. Eu gostaria primeiramente de parabenizar na pessoa da professora Paula Monteiro pela organização desse evento. Registrar que aqui no Brasil, e a Paula me parece que é uma professora que representa muito isso, existe uma questão de gênero muito importante na formação e institucionalização das clínicas jurídicas do Brasil. Não é à toa que a gente vê a Paula tão envolvida nesse evento, inserindo a pauta das clínicas na Universidade Mackenzie, integrando outros professores e professoras em relação a esse tema aqui no Brasil. A Universidade Mackenzie está no seu 2º evento, né? Paulo pode me corrigir, talvez, mas o 2º evento sobre clínicas. Então, um trabalho primoroso, eu diria, em relação a esse debate contínuo. Apesar das clínicas serem muito mais recentes aqui no Brasil, comparativamente à América Latina e aos Estados Unidos, a gente tem boas experiências, e esse evento certamente só vai qualificar ainda mais a nossa atuação, com a temática de como construir clínicas, que é um tema importante tanto para nós, que já temos as nossas clínicas, para qualificar, mas também para aqueles professores, professoras que queiram construir novas clínicas aqui no Brasil. Então, primeiramente, a gente vai ter a apresentação do professor Jeff Baker, né? E a professora Rosário também vai fazer sua apresentação na sequência, e ao final a gente abre para as perguntas e questionamentos, como vem sendo feito no decorrer do evento, né? Então a gente tem os questionamentos lá pelo YouTube, e eventualmente aqui, se algum professor estiver participando, quiser também enviar seus questionamentos. It's a pleasure to us attend our conference today. You have I don't remember, 1 hour or 25 minutes, 1 hour to talk about how to build a legal clinic. And after that, we will pose some questions.
Good. Thank you so much. We are very grateful to be here. This is a truly global event. One of the gifts of the pandemic has been to create these opportunities, and with our science fiction technology, we can connect all around the world. So good day from Sao Paulo, good morning from Los Angeles, good evening from Manila. We are all connected across hemispheres and around the world, 15 hours ahead of each other. So very happy to be here with my friend, Professor Olivas-Quinto. I will probably refer to her as Chato. She will refer to me as Jeff. And we are happy to work with you all. I'm happy to be here with my friend Paula, who has led this conference. This was her vision. This was her work. A lot of people at the opening yesterday made a lot of long and wonderful and generous introductions, but it's really Paula who is at the heart of this enterprise and has made this conference go and has brought us all together. So thank you, Paula. To Chato, my new friend, over this last year and a half, I'm grateful to work with you. We have more plans that we're going to talk about throughout this day, our session here about our work together. in Manila and in the Philippines, which has a very interesting situation in this new year that Chato will discuss. I'm going to talk about our plans for the session. I'm going to not leave my PowerPoint up for the entire time, but I am going to try to share in just a moment my slides so that we can see it. To my colleagues on the screen, you can see my slides now. Is that good? Can you see them? Okay, good. Well, I'm going to present them properly. So for the record, this is who we are. I'm Jeff Baker at Pepperdine Caruso School of Law in Los Angeles. Professor Olivas-Quinto is at De La Salle University in Manila. And we're going to talk about how to start a new clinic design and development. And I believe very strongly that any law school anywhere can start a clinic. There are going to be questions of budgets, questions of personnel, questions of bureaucracy, but there's also questions of teaching and practice. And we're going to walk through some of the processes of doing that in any school, in any context, which I believe we can and should do. I will also point out that we are going to have an experiment with questions because we're meeting on Microsoft Teams and broadcasting on YouTube. We can't take questions in the chat where we are, but we would love to receive questions or comments from you either in the YouTube live stream comments as we go. We will try to watch those and we will try to look at them as we go. I'm grateful for our Brazilian colleagues here who can translate Portuguese if they come that way. You can also hit me up at Twitter at JRBProf. If you want to tweet questions at me during the session, I will try to watch it. And I will also try to watch my DMs, but that will be a little bit harder. And then if you want to do it the old-fashioned way, you can email either of us at these addresses, and we will try to receive your questions. So I will leave that up for just a moment so that you can write it down if you'd like, but we would happily receive your questions either in the YouTube live stream or on Twitter at JRBProf. Follow me, subscribe below, and you can send us email if you want that way as well. So our plan for this session is that we're going to introduce ourselves and introduce the work that we do at our schools. Then we're going to talk about our experience designing new clinics and some of the lessons that we've learned from our work building new clinics in our own schools where we have done this together, where we've each done this. Then we're going to go through a process of questions and factors to consider when designing a new clinic and how to go about the process of building a new clinic in the context of a law school, in a city, in a country, and navigating all of the needs of students and clients, administrators, and teachers. Then we'll have some closing thoughts, and then we will answer some questions. So that's our plan for the hour coming up, and excited to have the conversation. So I am going to stop sharing and ask my colleague to continue. Chato, please introduce yourself and your work.
All right. So I am the Assistant Dean for Clinical Legal Education in De La Salle University. I have been teaching in the law school for 11 years already, and most of my subjects in the past years are about remedial law or procedural law. And I've also been in the practice of law for 32 years. I took my oath as an attorney in 1988. I finished law in 1987 from the University of the Philippines. And my practice has been mainly in litigation. I've been a litigation attorney for most of my practice. There was also a time when I engaged in international law, speaking up for refugee rights. I worked with I worked with Christian Solidarity Worldwide in Hong Kong. And so we assisted refugees in their applications for asylum with the Hong Kong Refugee Assistance Center, and their applications were filed with the United Nations UNHCR. All right. So that's basically my experience. I've had a lot of human rights experience, and I also have had a lot of experience handling cases for the rights of women, children, and political detainees. Okay, so that is basically who I am and where I come from.
That was interesting, and I know that you were even more interesting than that. So thank you. I am Jeff Baker. I have been an attorney in practice for 21 years. I graduated from law school in 2000. I returned to my home state of Mississippi in the United States, which is a small southern, relatively poor and agrarian state where I grew up, with a very interesting history and lots of art and culture. And I practiced there in private practice for 6 years. I was in a law firm and handled general civil litigation matters, defending hospitals and doctors, companies and insurance work. And I learned how to litigate. I had a trial and appellate practice there. And it was interesting work, but it was not the work that my heart and my soul wanted to do. So I left and began teaching at a university in Alabama, which is nearby Mississippi, called Faulkner University Jones School of Law. And there I learned about clinical education. I did not take clinics when I was a student, but at Faulkner, I was the first ever clinical director and had the opportunity to begin clinic teaching, and that was the first situation where I learned how to design a new clinic. At Faulkner, I ran 2 clinics. One was a domestic violence clinic where we represented victims of domestic violence in receiving civil protection orders and working with police and prosecutors, nurses, shelter professionals, and others to take care of people who were in abusive relationships. And then also started a clinic there called an elder law clinic, where we helped people who were old and aging, elderly, to handle their estate, wills, trust, powers of attorney, helping people put their affairs in order as they aged for their families. 8 years ago, I moved from Alabama to Los Angeles, where I teach now at Pepperdine Caruso School of Law, where I'm the Assistant Dean of Clinical Education and Global Programs. We have 10 clinics in the law school, and I direct all of them, and then I have an extraordinary clinical faculty who teaches each of the clinics. And the clinics that I run here, which I began from its foundation, what is called the Community Justice Clinic, and we represent NGOs, charitable organizations, churches, community organizations who are working with vulnerable and marginalized populations to advance social justice, economic development, human rights, and the engagement of people with their communities. I've also started, while here, a disaster relief clinic because we have had many natural disasters in our area, including hurricanes in Texas and then wildfires in California. So we have learned how to start clinics even in the middle of natural disasters, which is part of the story that I will tell in a minute. So that's the story that I have to tell so far, and happy to be here with you all. Chato, please explain your experience recently with Philippines' new law around legal clinics and your law school's response and the programs that you've started.
All right. In 2019, In 2019, our Supreme Court passed the revised law student practice rule, requiring all law schools to have legal clinics as a requirement for the students to take the bar in the year 2023 and after. So all of us, we are now mandated to set up our legal clinics so that our law students can comply with that requirement and take the bar. That was in 2019. I mean, the rules were passed in 2019, 2020, and that is to take effect this academic year, 2020 to 2021, for students who will take the bar in 2023. However, our law school was established in 2010, and we already had our legal clinic shortly after it was established. We call it the Developmental Legal Advocacy Center. Now, at that time, our focus was human rights cases and the cases of people around the community where our law school was located. We conducted legal missions in other places where our students with supervising attorneys went to different places to give seminars on environmental law and also on reconstitution of documents that were lost in the floods. You know, you heard of this big flood in the Visayas, and so many people died, so many were injured, and basic documents, civil registry documents were lost and destroyed. So our law students went there to assist the citizens on how to reconstitute their legal documents. Uh, and then, so we have legal missions that we conduct in communities. Some of our law students conduct seminars on how the women and children can deal with abuse situations and what cases they can file. Now, so in 2019, the Supreme Court issued that administrative order, and the goal of the Supreme Court was to produce practice ready lawyers. So, with that, we had to reorient our legal clinic, not just to accept cases, not just to have legal missions, but to make law students practice ready by the time they finish law school. And so I had the opportunity to meet up with Jeff Baker in the year 2019 and interview him because we were implementing that rule. How do you make your students practice ready? What do you need? What do you need to do? What do we need to do? And so, based on the inputs and suggestions provided by Jeff, we fashioned our law student practice, or what we call our experiential learning course in De La Salle University. Now, it is, I would say, in a way, it makes our task easier because the Supreme Court set definite guidelines for us, like what certifications are needed by our law student practitioners in order to be able to engage in limited law practice. So this is interesting because the Supreme Court is allowing them to engage in limited law practice, but they have to apply for a certification with the executive judge of the regional trial court that has territorial jurisdiction over the law school. Okay. And when they apply for a certification, that means the students will have to take an oath similar to the oath of an attorney to comply with the code of professional responsibility and uh, subject to certain sanctions if they commit violations. So the students, even if they are law students, they have this sense of how important their commitments are as attorneys. Now, the administrative matter issued by the Supreme Court provides for two kinds of certifications. We have level one certification for those who have finished first year in law school, and level two certification for those who are in third year in law school. So the certifications that they have will dictate what kind of legal service they can provide. For level one certified law student practitioners, they can interview prospective clients, they can give legal advice, they can negotiate, they can draft documents, and they can represent parties before administrative bodies, and they can provide public legal orientation. But of course, this must be done with the supervision of our supervising attorneys who take primary responsibility for their work. For those who are in level 2 certification, they can do all the tasks that an L1 certified law student can do. Plus, they can assist in taking depositions. They can prepare judicial affidavits. They can appear on behalf of a client at any stage of trial or proceedings before any court, quasi-judicial or administrative body. And in criminal cases, they can appear for the prosecution. In appealed cases, they can prepare pleadings. So they may also sign briefs, pleadings, and letters and documents. But of course, this must be together with the signature of the supervising lawyer. They cannot do this alone. Even when they appear in court, they cannot appear in court alone. Although they can sit in the seats of the attorneys, they have to be there together with a supervising lawyer. And then, so we have to follow these guidelines in order, and that makes it pretty easy for us because we already have set guidelines for our law student practitioners. But for the kinds of cases we are going to take, it depends on us. The primary goal of the Supreme Court is to provide indigent litigants with legal services. So we have 125 law schools all over the Philippines. So because of this, the indigents will have the opportunity to get legal services from 125 law schools in addition to the NGOs, the non-governmental organizations, and public interest offices. However, for our law school, we have decided not to accept all cases, but we will be accepting cases, and we have been accepting cases based on their educational value or pedagogical value. This is one of the guidelines that I received from Jeff when I consulted him. Like, we have to pay attention to the kinds of cases so that our law students will have maximum learning from these cases and matters. And we don't just accept cases, we also have transactions. So non-litigation matters. We only have one legal clinic, but our legal clinic is run like a law firm, like a law firm with several areas, several kinds of cases that we handle. And our dean and myself, we serve as the partners, and then we have our supervising attorneys, and the level 2 certified students function as senior associates, and the level 1 certified students function as the junior associates. So all of us, we work together in teams in order to handle cases and matters. We are also developing a network with non-governmental organizations, the Integrated Bar of the Philippines, so that we can have a referral system for cases that we cannot handle. Like, we cannot just leave clients out in the cold, and so we have a referral system for clients whose cases we cannot handle. At the same time, we also receive referrals from the Integrated Bar and other organizations. And we are developing a network with psychologists, the DNA specialists, and other experts so that we can work together with them when necessary. So far, this has been our experience in implementing the law student practice rule that was recently issued by our Supreme Court.
Thank you so much. It's an interesting situation where the Supreme Court of the nation orders all of the law schools to start clinics,
Yes.
which to me is exciting, also quite a challenge for the law schools to need to rise to that occasion. In the United States, we do not have a requirement that law schools offer clinics, but we do have, and our accreditation of law schools, most law schools, is through the American Bar Association, which is not a governmental body. So in some countries like the Philippines and perhaps many others, the bar and law schools are governed by the judiciary and the government. In the United States, it's not, and it's a bit of an interactive process where the law schools have influence on what the rules are, and then the American Bar Association can influence what law schools do. But we do have a requirement that students have some kind of experiential learning, and most U.S. Nationally accredited law schools do have clinics. Everyone has externships, which is a way for students to work outside the law school as well. I'm going to integrate my story a little bit while I walk through some of the questions. Chato, Professor Olivas-Quinto has done an excellent job of explaining her process and many of the means of deciding how to establish a clinic as they go. And I want to illustrate that just a little bit. I'm going to share my screen again. And hope that you can see them. Can you see where I am with my screen? Okay, good, thanks. So I'd like to talk about a few of these big ideas and about some theories of legal education. And the story that Chato just shared illustrates many of these things. And I would like to talk about some of the major goals, the theories of clinical education, because of this idea that I would like to introduce called backwards design. This is not new to me. It's not original to me. I received it from clinical colleagues at our clinical conferences years ago. Backwards design is the idea that you begin with the goal. We begin by thinking about the clinic that we want to have, or the values or the objectives that we want to achieve. And then we build up toward those goals. And so these are some of the most important goals for clinical education that we think about as educators and as teachers. This idea of professional formation is really important. There was a book years in the 1990s in the United States that came out. We refer to it as the Carnegie Report, and it talked about professional education in 3 apprenticeships, basically 3 categories of learning, 3 categories of teaching that professional schools like law schools should pursue. The first idea, the first apprenticeship, is the cognitive idea. That is the idea that we are learning about the law, learning what the law is, learning about theory, learning about jurisprudence, learning about the basis and the substance of the law in our countries, in our states. What is the law? The second apprenticeship is technical formation, the technique, the craft of being a lawyer, how to write, how to research, how to advocate. And most of those things happen through simulations, through classroom exercises, through modeling in class how to do these things that lawyers do. And the third apprenticeship is the professional formation. This is the combination, the synthesizing of doctrine and technique, the knowledge of the law and the craft of being a lawyer with the service of a client. So this is the idea that Chato referred to as practice readiness or client readiness. It is taking a law student not from just thinking like a lawyer, but to being a lawyer. Taking the things that we have learned, the lessons about the law, the technique and the practice that we have done in class about writing and research or advocacy, and then doing that with a real live client. And there is nothing like it. If we've been in clinical education for long, there is magic that happens when a student meets a client for the first time and realizes that they can really help them. And that is this idea that I refer to as the shift. It is the shift, the change that happens in a student's mind when they move from a classroom to a client. And this happens through several different ideas. These are the foundations of clinical education. Non-directive teaching is the idea that clinical teachers are not just telling a student what to do, but are guiding them through the process of what to do, giving students as much responsibility and autonomy and independence as possible. So we don't want to harm a client. We don't want to create malpractice, but we teach the students what to do, and then we let them do it. And then we let them talk about what it is that they've done. And that is reflective practice. Reflective practice is the idea that we prepare a student for a task, for a client, and then we let them perform that task with that client on their own. And then we bring them back to reflect on what they did, to think about it, to identify what they did well, what they did poorly, how to improve it, and how to get better next time. And then last in clinical teaching is this idea called learning for transfer. And this is the idea that whatever we do in clinics will and should apply to any other kind of practice that the student will have in the future. So a client interview with one client, for instance, in the clinic that Chato was describing, helping indigent clients with their paperwork, that is a very straightforward, discrete task that a student can do for a client. But learning to interview a client, to explain the law, to help them solve a problem, to recognize a problem, to recognize a solution, and to help the client get there, that's what lawyering is all the time, everywhere. So the things that we can build into a clinic can help students move on in every direction. So with these ideas in mind, I believe that we can design and create clinics in almost any context for almost any practice area that will serve all of these goals. This last idea I think is very important. We need to trust our students to do good work, but only after we have set very clear expectations for them. I think it is very important that they understand what they're doing, and the students understand why they are doing it as an educational goal, and then that we trust them to do that, because I think the higher expectations we have for our students, the better that they will do. And of course, there is a very important aspect of clinical education, and that is increasing access to justice for people who need it. In every country I've ever been in, from the US to the UK, Brazil, India, the Philippines, I have seen that there are great gaps between the services that lawyers can provide, even the public interest and pro bono lawyers, and the needs of clients. And so our clinics, like Chato described under the Philippines new rule, is to increase services to clients in great need. This also helps instill in students a value of pro bono work, of serving as public citizens in their practice. And it also creates inclusion and empowerment and helps advance the rule of law, because if more people have access to justice, then the rule of law will be all the stronger. So those are our goals. And these are some of the important questions that I believe we have when we are looking to design a clinic. I'm going to just open them all up, because we've already seen through Chato's story many of these things in action. So I believe we should always start with this. When we're starting to design a new clinic, we need to say, what do we want to teach the students, and what are our educational objectives? We start there before we start building a clinic. We start with what we want to teach them. Sometimes that will be general. We want to teach them how to be effective lawyers and ready for a client. But then we can get more specific. I want to teach my students how to be a really good lawyer in court, or a really good lawyer writing appellate briefs, or a really good lawyer helping families navigate and mediate their disputes, or helping a client start a new business. All of those things are appropriate for clinics, and we need to decide first what we're trying to teach and why. That's the first question. Then as clinic design goes, I think we need to talk about how many students we hope to teach, or how many students we have to teach. In the US, we have a guideline, not a rule, but what we call a best practice of trying to make clinics be in an 8-to-1 faculty-student ratio. So 1 teacher per 8 students. At my school, we have one teacher per 10 students. And we have negotiated that in order to make sure that we have really good coverage for our students and good teaching and good reflective practice and supervision, but also to have more students involved in clinics. In some places, like the schools in the Philippines, it needs to be every student needs to come through a clinic, or every school needs to offer these opportunities to every student. So that will inform design decisions about how many students we need to teach. And related to that is how many teachers or lawyers will we need to supervise students to direct the practice and teach the classes. If you have an unlimited number of supervising attorneys, then you can have very small clinics with very focused supervision. If you don't, and no one does, then we have to decide how those teachers and lawyers are going to supervise those students and how many they're going to supervise. Then I think we talk about what kind of practice would accomplish these goals. What kind of work can serve those educational goals? And then we look to see where the client needs are for pro bono services. Now, this is a big question. And it is a question that is endemic and at the core of a lot of clinical teaching everywhere. Do clinics exist mostly and primarily to teach, or do they exist primarily to expand access to justice and serve clients? Now, it is both. But I believe that if we approach the clinics as only or primarily for serving clients and the greatest number of clients, then we will build a clinic that has certain features, and that is good. I'm not saying it's not. That is a good way to teach, but certain decisions will be affected by whether we want to serve as many clients as possible or whether we want to teach students in a particular way. So sometimes there is tension between the pedagogy and the practice. How are we going to teach versus how are we going to practice? And if teaching is our first goal, then as Chato suggested, we will take cases that are best for teaching. And we might take fewer cases in order to give students more responsibility over fewer and simpler cases. But if we want to take many more complex cases or many more students, many more clients, then the students may have to work under the heavier supervision of supervising attorneys who need to be more efficient and handle more cases. So there are no right answers to these questions. These are just the things we need to consider. And here are some more important questions that we will all have to ask as we go. What resources may the school commit to the clinic? How many faculty members? How much space in the building? What rooms or buildings do we get? How much money is there in the budget? These are obvious questions. And if the answer is none, then it will probably be one faculty member who's having to use her ability to teach classes in order to in exchange for supervising the clinic. It might be a classroom. It might be space with a legal aid agency or a pro bono public interest agency, which is part of the second question. What partners could work with the school? Paula and I are having a session tomorrow on this question about the importance of working with collaborators and partners in the community, because that can make our work stronger. Who will be the lawyers of record with professional responsibility for the clients? Chato just talked about the need for students to be supervised and approved by courts at different levels. We have a different system in the US. Usually the clients here, our clinics clients are ours. My law license governs our clinic, and so I am the lawyer of record. Sometimes we have supervising attorneys who help as well in US clinics. And then what are the government or bar rules on student practice, as Chato just described. So as we're thinking about how to design a clinic, these are all very, very important questions. And I'll raise just a few more, which I've already mentioned. What should be the clinic's scope of practice? Is it full services? Is it limited scope? Are we only doing advice? Our friend we heard from yesterday in London, Alan Russell and Andrew Unger, are running an advice clinic where they provide one-time advice to clients at a great number of clients with a lot of student activity. My clinic that I run is much more full service for nonprofits and NGOs. So my students have 1 or 2 clients during a semester, and they do big projects for them rather than many, many different interviews. All of those are valid forms and effective forms of teaching. Will this be a class for academics credit, or will it be outside and extracurricular? And then, of course, we always have to figure out the problems that we're going to solve along the way. So those are the questions that we often see as we design clinics. And I would like to say that that's just an easy framework, and we can share those slides as well if Paula would like. And if anyone asks for them, I don't know if they will. But those are some of the processes that we have gone through to learn how to design new clinics. I think that it is a very iterative process. And by that, I mean, I think that it requires a lot of experiment and that it requires a lot of change as we go through that process. So we begin with these questions. We answer them as we go. And if we have time, I can explain how we've done this for our disaster clinic as well. But I'd like to stop and ask Chato to respond to those questions and how that has worked with her clinics at De La Salle.
Microphone is muted. Yeah. So a lot of your questions that you put up in backward design of a legal clinic, this is very important for us. And I think I would like to speak not only for De La Salle, but for the different law schools in our country. All those factors are important in considering what kind of legal clinic to put and all the resources necessary. For like how many law students do we have? We actually, you will be surprised, we have 145 law interns this semester. Okay, around half of them are in 3rd year and around half of them are in 4th year. So we divided them into teams, and there are 27 teams now. We have 4 supervising attorneys. So I think we can compare our practice to that of a small to medium-sized law firm here in the Philippines. We are based on the factors that you mentioned. We are not accepting all kinds of cases, and although we can consider ourselves not as a very limited practice, but we want the students to have a wide variety of exposure in litigation and transactions. So, the backward design, the questions that you have, they are very important to us as we navigate on how to make our legal clinic stronger. Our dean tells me that we are building the legal clinic. We are building the plane as we fly. That's what he says, because we really have no prior experience in this. And the feedback that you have given to us is quite important. I believe not only for us, but for our other law schools. For La Salle, providing a law firm, hiring supervising attorneys, it's not really a problem to us financially, because we are one of the law schools with which we consider high end. We do have a budget for that. but I believe that many other law schools would benefit so much from the backward design big questions that you have, because it will help them come up with their own programs, especially with their very limited resources. Yeah, so that I would like to be working more together with you, together with our other law schools, because we can learn a lot from your backward design on how to set up your legal clinic. Now, I just have a question for you. Is that okay? Um, how do you decide on the type? Because us, we have one law firm which handles different kinds of cases and matters. So that is our legal clinic. Although in some law schools, they have their own, like women's rights clinic, children's rights clinic, and all that, like the University of the Philippines. So I understand in Pepperdine, you have your law clinic per subject. Okay. How do you decide on what type of legal clinic to put up?
That is such a good question, and there's no universal answer for that. In the United States, that has been the typical evolution of clinics. They began the clinical movement in the United States began really in earnest in probably the 1940s, 1950s after World War II, and it began really as an effort just to provide legal aid to communities, and then it has grown from there as it's become more specialized. Sometimes the choice of what clinic to design is based on the professor's interest and the professor's expertise and whom we could hire to do that kind of work. Sometimes it is based in the curriculum and looking at what kind of practice that we want to have that we don't already offer, to try to provide more and more diverse opportunities for students. And then sometimes it's the demand of a community, what we need to do and what the community has a great need for. We have, over the last 10, 15 years, we have seen just an explosion in immigration clinics in the United States from coast to coast, because we have such a complex and really problematic and challenging immigration system. And so that has become a very good way to meet a community need with professors who understand that work and cases that are a good fit for what students can do on their own. I'll tell you a brief story about my experience here at Pepperdine. All of my experience for the first 13 years of my practice had been in litigation. I was a trial and appellate lawyer of some kind. So I was always in court representing individuals, especially when I was in my domestic violence practice. And honestly, I was tired and burned out, and my spirit was bruised from 400 or more domestic violence cases over 7 years. And when I moved to Pepperdine, all of the clinics that we had were all based on representing individuals, and they were all representing individuals in court, some kind of court, whether this was for housing or family law or education or something. We recognized a need to have a clinic that served not just individuals, but organizations, because a lot of our students will come out and represent businesses or represent NGOs or other kinds of organizations, which is a different kind of practice. And also to have things that were other than litigation. And I was ready for a change. And so we designed the Community Justice Clinic, which I still run 8 years later, which provides basically general legal services to nonprofits and NGOs. So we help nonprofits, charities, and NGOs organize. We help them incorporate, get tax exemption, get their status. We help them with contracts, with trademarks, with personnel issues, with transactions. And we also have a pretty robust international and foreign practice as well in my clinic. And that was just something that didn't exist. So part of it was my desire to do something else, but part of it was looking at the curriculum to see something that we could do that we didn't do that met a need. We also had a situation in 2017 where a major hurricane hit Texas, which is not near California, but is near where I used to live and where I have a lot of friends. And I lived through our famous Hurricane Katrina in 2005 and recognized that there was a need. So we started a pilot project to help on very simple applications for people to get government benefits after the hurricane with our friends in Texas. And it was just going to be a short clinic, and we were going to close it up, and we did. But then in late 2018, we had a major wildfire in our area here in California that burned 65,000 acres, including our city and our campus, and burned very near our homes and displaced many of our neighbors here in our town in Malibu outside of Los Angeles. And so we immediately started the disaster relief clinic again out of an incredible need in our community. And at first, it was just students and teachers volunteering our time. We were not getting paid for it. We were just doing it to help our community. Over time, we've received grants. We've received more support from the school, and it continues. And we expanded our disaster practice from hurricanes to wildfires to now pandemic response as well. So that was a clinic that arose out of a great need in the community, but we still used all of these features to think about how many students we could serve, how many clients we could serve, and how it was going to be good pedagogy along the way. And this raises another interesting, at least interesting to me. One thing that I have found to be true of clinics in the United States, and as I've learned about clinical programs around the world, there is no prevailing or best model. I think it is impossible to point at any clinic and say that is the best clinic and everyone should follow it. I believe that context is everything. The context of a school, the context of a city, the context of a country, the context of a community, and the finances and the bar. And so what we have to have in our mind is, how am I going to build a clinic that serves all of these needs best in my context, in the context of my school? And that's why I like to start not by looking at other schools, but by looking at our own community and then thinking about what the best values, the best principles of clinical teaching are. And then we build up a clinic to try to meet those needs within our context. So I am not holding out my clinic as a model for anyone, but I think the process we can apply the process in any place, especially in countries that have a sense of the rule of law and constitutional government within a representative government, because this is the purpose of lawyers and it's the purpose of law schools. That can be my last word. Chato, do you have any final thoughts before we turn to our last phase?
Yes, for me, it is just so important for law students to be practice ready. And schools will be at a very good advantage to produce practice-ready lawyers. I think this should be the primary objective of a legal clinic, so that the students will be able to integrate theory with practice. So the students will have a clear idea of how the procedural law, remedial law, and substantive law, how they work in real life. And what's important is it will make them less afraid of going into law practice after they graduate, because they will have a clear idea of what they are facing. So I actually welcome this development of our Supreme Court requiring experiential learning as a requirement for the bar exam. And I am very happy to be part of this Clinical Legal Education International Conference to learn a lot from the experiences of other law schools.
Yes. Well, thank you so much. Professors in Brazil, other thoughts, questions, contributions? I would love to hear about your programs as well.
Paul, I don't know if we have questions from YouTube, but I would like to comment and put some questions. I think the most important idea is the last one about the context, because if we want to create a clinic, a legal clinic here in Brazil, we must look at the reality too, and try to build this clinic from this reality and from our experiences, and from then, in my opinion, that's the most important idea. And I have one question about the point that you talk about trust and expectations. Mm-hmm. In my opinion, is a hard question, because the students are just students yet. At the same time, we have some expectation from clients. And my question is, what kind of expectations we as professors can or can't have from students? Because sometimes the students' work are not good. The reality, you know? And what to do with this? What what to do with this as professor and with the students, and what kind of answer to give for the client and things like that. If you have some examples.
I do. I'd like to answer with a story, and then I certainly welcome Chato to explain her situation too. I'll say in the United States, we have, I don't know if this is better or worse, but our law students are all graduate students. So our students are not teenagers when they start. They've already finished college and they're in law school. Excuse me just a minute. So my story, though, when I first started clinic teaching, I had been a supervisor. I had been an attorney in a law firm for 6 years, and I was not yet a partner, but I was a senior associate, and I had partners who supervised me and told me what to do. And then I had junior associates, and I supervised them and told them what to do. But we were all telling each other what to do. And the concern was not about teaching me or anyone how to be a good lawyer. It was about serving clients. And so I had bosses, and I was a boss, and we were serving clients, and that's what we did. When I started teaching, I made a huge mistake as an early teacher, and I treated my students as if I were their boss. I was managing a law practice, and I was managing students, and I was trying to make sure that everything they did was right for the sake of the client. I mean, that's not wrong. I mean, I was trying to teach the students how to be good lawyers, but I was doing it in a very directive way. And if they made a mistake, I got mad at them and I reprimanded them, and I was very stern, and I could tell that they were just not learning. I mean, I could tell they were not getting what I needed them to get, and it was very frustrating. After my first year, I went to go talk to a mentor of mine, one of my professors in law school, who is a very experienced clinical teacher. And I asked her about this problem, and I was, for instance, I said, how do you handle client interviews when the students are going to go see clients? How do you supervise them? Because when I go, if anything goes wrong, the students look at me and the clients look at me, and I end up taking over and I end up doing it because I don't want the students to mess up and make a mistake. And she said, oh, I never go to client interviews ever. And it made me terrified. I was scared. I was like, how can you not? What if they make a mistake? And she said, so what? If they make a mistake, they can go back and fix it. And what she told me was, the idea is to prepare the students in advance well, to explain to them what the objectives and the goals and the expectations are, to practice with them, to get them ready, then send them out to do it and don't go. And then when they come back, ask them how it went, discuss it with them, ask them questions. That's the reflective process. And this is the difference between directive supervision and non-directive supervision and reflective practice. And so I was scared, but I took a deep breath. I dove in. I stopped going to client interviews, and my students did better and better and better, because when I was not there, they knew that it was on them, and it was and their expectations were that they had to do it well. And it's like doing the trapeze without a net. If you're doing the trapeze in the circus without a net, then you hold on tight, right? Instead of falling off. And so they do better. And so that illustrates my point of trying to teach them what they need to do at a very high level, but then trusting them to do it. And then but they need to know that I'm trusting them to do it. And when they know what their expectations are, and they know that I'm trusting them to do it, then they will rise and they will do it. And if they don't, then it is just a problem to fix. And my last thought on that is I stopped treating mistakes with anger, and I started treating mistakes as opportunities to teach and to say, what went wrong? How do you fix it? What do you do? Rather than just getting mad when a student messes up. And I think that is better clinical teaching. Chato, do you have ideas on that?
Yes. Now, this brings me back to my early practice in litigation. I learned about litigation because I was like an apprentice of a senior partner, a litigator. I was going with him in trials. I was there when he interviewed clients. I was there when he was researching, and he was giving me assignments for research. In other words, I was watching him and observing how he did it. And I learned a lot because he was not telling me what to do, but I saw what he did, even in litigation. To the point that there were times when he, for example, in litigation, he conducted a direct and cross-examination of the witnesses. There was a time when he told me, after so many witnesses were presented, he told me, there and then, Chato, it's your turn to present our witness. There and then. So, well, I just had to learn how to do it if I were him. And so it was more of learning by example. That was my experience. And to me, that was very good because he was the best litigation lawyer in the law firm. That was very good. Now, in our law school, our law students are also graduate students, but some of them are very young. Uh, some of them are 20 years old, 21, some are even 19 years old. So when they go out and clients ask them questions, they tend to be careless because they are very excited. So one time I observed them, and they tend to be very excited and careless in the sense that when the client gives them information, they give advice immediately without getting all the information. So I tell them, this should not be done. You have to get all the facts before you can render legal advice, because the clients will rely on you. Now, with the student practice rule and the oath that the students have to take in order to engage in law student practice, that they take the oath as if they are already attorneys, I think this will make them realize how important it is to give legal advice. They will not be careless. Well, of course, we can always tell them, we can always teach them, but the excitement of being able to give advice immediately, it's something we have to control, especially if they are not that well versed in different aspects of the law. So, anyway, the limited practice that they have under our student practice rule is a good way of providing them with limitations, and at the same time setting high expectations because they have to give their best. That is their commitment to the client with the oath that they are taking. This will make them more careful. This will make them study better before giving legal advice. And this will make them understand that clients trust what they say. And more so, it will make them understand that they have liabilities if they are not properly preparing when they give legal advice. So I think this is an advantage that we have. If we, drive into our students' minds how serious this business of lawyering is. In fact, they are subjected to sanctions if they commit violations of the Code of Professional Responsibility, even as law student practitioners. So to me, that is a very good advantage. And plus the fact that they could be subjected to disciplinary action by the Supreme Court because this is a requirement for taking the bar. So I think, yeah, that's a good thing for us, for our law education system. I just hope that the students will not be so afraid. I would like them to be very reflective in studying very well, in being very responsible in providing legal advice to our clients, and not being careless in providing legal services.
I will only add, my problem with students usually is not that they're trying to do too much, is that they're trying to do too little. They don't trust themselves. They are terrified. They are afraid of real live humans. They like books, but they get worried about people. And so I have to build in trust for themselves too, and talk about how the process of lawyering is more important than their expertise in any sort of law. So getting mine, usually I have to push them instead of hold them back. But Professor, what is your experience in Brazil at your clinic? How do you handle these issues as well when you're doing it? You're muted. I want to hear your answer though.
Well, we have different kinds of students here in Brazil. It depends of the university, I think. I don't know if Paula agree with me, but well. But sometimes we work in a hard case, in a complex case, and we must have a good job. We have to do a job in a high level. And sometimes our students don't have time, they work, they are at the university, but they work too, they don't have time to work a lot. And this is our reality. Then we must consider this, and sometimes we must to put our effort in this work to make complements. And this is, in my opinion, it's a very important question to professors want to create a clinic in Brazil, that we must consider this extra work sometimes, because if you want to safeguard the interests of clients in some extent, we must put extra work in sometimes in some cases. Well, this is my reality in my university. Sometimes we have very good jobs, but sometimes no, and we work with this different kinds of results. And I don't know if we maybe Paula talk a little bit in Portuguese for the students are listeners. I don't know.
If you want, you can talk a little bit in Portuguese for those who are listening to us. And after you, I'll pass to Alan, who's here. He's from the London South Bank, and he was here yesterday. So, Professor Taysa, you are free to talk in Portuguese a little bit, and then we pass to Alan.
Or maybe we listen the questions from Alan. Hi, Alan.
Okay.
I don't know. Não sei o que vocês preferem. What do you prefer?
Yeah, no, we can hear Alan, and then we talk a little bit in Portuguese. It's fine. It's okay. Alan, if you want to say something, I saw you from the beginning.
Yeah,
but before Alan, let me give Alan his due, and let me make some brief introductions. So Chato, no, come back. This is Alan Russell, who is our friend from London. Alan, turn your video back on. Who runs the legal advice clinic that I referenced earlier. I don't know if you heard me bragging on you, at London South Bank University, which does a legal advice clinic, and Brazil brought us together, but the last time I saw Alan, we were having a beer together at an Indian restaurant near King's College. So, Alan, please share your wisdom for us all.
Yeah, that's right, Jeff. Thanks, and yeah, thanks for letting me just contribute. I was kind of riffing on something you were saying, Jeff, because it's really interesting what you were saying about trusting students and that change. You know, from when you're coming out of practice with them there all the time, making sure they don't do anything wrong. Getting angry with them if they did, and then completely stepping away from that and preparing them, letting them have a go, and then reflecting after. You talked about the model in our clinic where we see lots of people really quickly and we give them advice. So there's kind of no time. If the students get it wrong, there's no time to go back and do it again. So we do sit in with the students. And I was really struck by what Jeff was saying, and that happens all the time. How do you manage making the students be not frightened to try and give it a go if you're there sitting on them? And it's really difficult. I mean, the positives about that is that there's two students, so they can, and a bit following from what you were saying, the Chato, I think is your name, is that they learn from me modeling it, they learn from the other student modeling it, and if you can, but to what make it have any chance of working is it absolutely has to be in a atmosphere of there is no problem if you make a mistake. It doesn't matter. If you make a mistake, I'm there and I can help you. So if you're not sure whether to ask that question, just ask it. Don't worry about it. If it's the wrong one, I'll stop you. And then did you hear? And then just being super positive. Like I think somebody mentioned, no criticism. Yeah. So that's the policy. However badly it's gone, there will always be something that the student has done well, and how important it is to focus on what the student has done well. And I always say, look, you did amazing. They think, oh, I was terrible. You did amazing. I say, it's the first time you've done this, or the second time you've done this. I've done it literally 20,000 times, you know, and you're like halfway there and you've only done it twice. And then by 10 times, they're all the way there. And there's some merit in that, in them seeing somebody who has a lot of experience, observing and witnessing them and attesting to their brilliance and their achievement and their progress. But you're absolutely right, Jeff. If you get that wrong and you're in there with the room and you're being critical and they feel like your eyes zoning in on them, it impedes the learning process. So I was just really struck because I was thinking, flipping out, we don't do that. We're in there all the time with them, and it's a different way of doing it. And it's by necessity. It comes back to your, you know, what's possible, because we did backwards kind of design to say, what do we want to achieve? And we got to this. And then as part of that design process, it means we have to be in the room with them. Okay, that was my contribution. And by the way, it's been fascinating and brilliant discussion. And from my point of view, it's great because it's in English, so I can understand it.
Yes, I am grateful to all of our Brazilian colleagues who endure our unilingual monolingual stuff. Yeah, well, thank you for contributing. And I just would like to say it's a great example that context does matter. And like Professor Taysa was saying, like we have to deal with our own reality. And I'll say that everything that you said is 99% true. Sometimes we have to jump in to save the day. Sometimes we have to take charge because something is complex or a client is in great need. And 1 out of every 300 students require me to not be nice. But whenever I'm not nice to a student, it's for their own good. And it's my last resort.
Yeah.
So sometimes we have to let it go. Chato, what would you add? Thank you, Alan.
Oh yeah, well, all of this is very interesting, and yeah, it takes a lot in order to trust the student to do it alone. Uh, I agree that I have to be in the room with them. Uh, they have to see me do it, and then I have to be confident enough to let them go, and I'm still there. And then I have to be even more confident to let them go, and I'm no longer there, and we will just discuss the results. So this will be in stages depending on the level of the students. Um, yeah, but it's important. It's important to tell them, I trust you. I think if we tell them that we trust them, it will make them even study more and be more careful and judicious in giving legal advice. So, yeah, thank you for that. Thank you for all your contribution.
I have another, I have another one question about how to run a clinic without money, because again, the context from Brazil, we can think about it. It's a very important thing for even in the private law schools or in the public. It's
I think that that it is just incredibly difficult, but I think it's not. I think it is possible, but only with support from a dean and only with support from the law school. And I think that the work there has to be some balance, right? You can't teach 4 classes and supervise a clinic. So if there's no money for it, if there is a willing professor, for instance, if you are willing to do it, and the dean and your university are willing to say, okay, your job is to teach a clinic, then you may be able to supervise students to build partnerships. I think having partnerships with other community organizations, with other government agencies, can be a very important way to help them and build a clinic. So if you can find a legal aid agency who needs more people working, more students, more supervising, then they may be supervising attorneys for free because it's helpful to their practice. And then you can oversee it if your dean and your university says, okay, you can spend 50% of your time doing this instead of teaching 2 more classes. So I think that's sort of the give and take, but that becomes a question of personnel and of time rather than money. But I think if you don't have time or money, then it may not be possible. And it's going to be that balance, or not for long, because you'll die.
Yeah, some law schools here in the Philippines are thinking of making a consortium, like several law schools all together, because they cannot put up their own legal clinic in their law school. Some of them are thinking of working together to put up one legal clinic for them, for several law schools. So that could also be a way of addressing your problem, sharing resources with each other. Although I don't think you can do it with absolutely no funding. You need to have some little funding in order to do that. Like, for example, one law school will make available their facilities, and other law schools will provide the supervising attorneys, and then the law students can work together in that one clinic where there are different supervising lawyers from different law schools. That is one possibility that some law schools here in the Philippines are thinking of if they cannot put up a law clinic in their own law school.
Let me also say a word for what we call externships, which are also field placements. And these are not clinics, but they are like cousins or siblings to clinics. So we have a separate program where our students can earn credit units for experiential learning by working outside under the supervision of others. So when we talk about clinics, I think we're talking about our own law school practices, our own law school programs. But most of our 90 or more percent of our students do externships where they're working under the supervision of other lawyers outside of our practice. And then we have guidance for those supervising attorneys about good teaching. And then we have faculty who are doing faculty supervision to make sure that they're getting a good experience. And so they're getting experience in the field, but it's more like having a job than it is being in a clinical class. So it's much more about observing and helping than it is reflective teaching practice. So it is a different kind of exposure, but it's important. It's just not the same thing. But they're cheaper, and they're cheaper to scale up. What do you think?
I think we have the same in Brazil with estágio supervisionado, externship, and it's a more work relation between and the clinic. We have more student-professor relationship, and I don't know. I think I don't know, Paula. What's your opinion about it? Now we are discussing all of the function of externships and clinics and extensions that we have here in Brazil. It's a different kind of activity we do in Brazil. I think it's only in Brazil, Argentina, maybe, that we call extensions. It's a kind of service that we give to the society. Then it's similar to the clinics, but it's something that we create here in Brazil. It's in Brazil and Latin America. Then we have these other kinds of activities that we can, and sometimes we must dialogue at university.
Yes, well, I share the concerns that we have too, Professor Taysa, that we have a lot of things that the law students, they must do, but the timing and the situation, the economic situation, sometimes it's hard for them to enjoy all the opportunities that the university has. And the legal clinic is such a great opportunity, but as Professor Taysa said, sometimes we don't have the funding to help students to change from internships to work in our clinics. And I believe that the chain that we are building together with the legal clinics now in Brazil, that I think it's different from 5 years ago, 3 years ago, that now we see other clinics working together, is a way that we can find to help students to appreciate, to enjoy, to know what a legal clinic is. And we know how important the practical work is for law students, especially when we deal with social things and social issues that we have here in Brazil. But also the timing sometimes, if you say you talk about the work, but in São Paulo reality, Jeff saw it, it's a big city, and sometimes they students live here, the classes are here, and his work is here. So it's very hard for them to be all around the business that they must do. But it's the things that we must think about, and the pandemic showed that we can have clinics in a virtual way. It's not the best way, but we can do it. So we are seeing some answer for those questions about funding, about timing, about them working. So that are my thoughts for today, but just this contribution, the panel is yours, but thank you so much for giving me the time to talk about it.
I'll take a last word and then invite Chato and Professor Taysa to close as well. I want to say thank you to all of you. I learned so much from working with wonderful creative professors all around the world in all of these contexts. I'm grateful for your work. I'm grateful for IBMEC and McKinsey. for co-hosting and sponsoring this conference, for Chato and De La Salle for their work that we do together and are going to do together, for Professor Taysa for moderating us, for Alan Russell for jumping in with his wisdom. I will never be able to grow my beard into the legendary length of Alan Russell's, among other reasons. I'll never live up to him. But thank you for, and there's a cameo of Professor Russell's beard, which is fantastic. Anyway, thank you for your great work. It's a pleasure to be here, and I'm grateful for you all and inspired by your work.
I don't know, Rosario?
All right. Thank you so much for having me. It's very interesting to listen to the experiences of others. And even if you're sharing, Professor Taysa and Prof. Paula was very short, I have been given a glimpse of how it is in your situation. It would be good for me to have more contact with you. I'm interested in you know doing more with you in your country, even virtually, as well as very much interested in working together with Jeff as we strengthen our legal clinic here in the Philippines. And thank you so much, Professor Russell. Your appearance was very brief, but I also learned a lot from you in that very brief appearance. I look forward to having more time with you in this conference.
Thank you both. It's a pleasure to us attend your conference. It's great for us in Brazil to listen and learn about your experience. And I don't know, Paula, if we have some questions or...
No, I think we're done. I think we're done, and we can give 2 minutes back to the world. So.
Yes. So Jeff provided his
Thank you so much. Thank you.
Thank you, Alan, for being with us today too. So I appreciate your presence, and we learned a lot from you. People that didn't see us right now, they're going to see us because it's going to be on YouTube forever. So I hope you can join the other panel. You can join the other panel in the afternoon. It was a great pleasure, and thank you again, Jeff. When I always say that Jeff is as crazy as me, and when I came up with the idea, he said, "Are you sure?" I said, "Yeah, we are a great team. We're going to do this together," and we did. And I'm very, very grateful and happy that we have the chance to talk about legal clinics in the international conference. So thank you so much. In the name of IBMEC, I thank you all for listening and for being here. Bye-bye. Thank you, Professor Chato. See you soon. Bye-bye, Professor Taysa. Thank you.
Bye-bye, all. Obrigado. Buenos dias.
Goodbye.
Bye-bye.